Hey, what's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. And in today's video, we're going to talk about these, specifically LVNV funding. Like, they just went on a massive tear of debt collection lawsuits. It's really affecting people. Like, I don't know, there's a lot of stuff when people try to scare people with stuff on YouTube. The economy is crashing, the sky is falling, credit card debt is at an all-time high. But there is nothing other than just, a person losing their job, losing all their income. I would say the next step on the financial level would be when a debt collector comes at you with a lawsuit, and they come at you at a time that you're not really expecting it, and they make their case or they present their case by putting a lot of information up against you from what they got from the original creditor, and and when people get it, they could have this feeling like there's not going to be anything that I'm going to be able to do about this. And what I have been noticing is that, like, there's a group of people who are like, I'm ready to fight this. Like, I want to fight it. Win or lose, I want to fight it. Then there's a group of people who they think that there's some type of way to just run from it. Like, like, if you don't say nothing to these people, that they're not going to proceed in court with doing what they, with the summons that they gave you. Like it's just going to stop. And that's not true. And then there's a group that gets the information. This is the group that, if you're one of the ones in this group here, this is the group that I think that if we could reach, it would make a huge difference. There's a groups of people, maybe you're one of the ones listening, that are being sued, where you think that you have to win to do something. You think that you have to actually know that you're going to win to do something. And that group right there is why debt collectors continue to do their stuff, continue to buy millions of dollars worth of debt and take people to court. It's because there's a large group of people who only believe that they should challenge a debt collection lawsuit if it was guaranteed that they were going to win. And there is no guarantee that you're going to win, because there's a whole bunch of variables that are in place. You have what the judge that could be hearing your case. You know that there could be not a relationship that would be unethical, but a relationship between the judge and the plaintiff attorney, because they're going to usually be one of these attorneys that are going into court every day for this stuff. You're only going to show up there 1 or 2 times. So there's going to be some sort of familiarity between those two, not to say that they're going to let them get away with stuff, but from experience, you have to handle that type of case different than you would handle someone that's coming in with a Zoom against you. The paperwork would be the same, but basically what you're doing is you're handling the situation with that attorney in a different way, because you got to give them some type of way to save face to back out. From experience, what I've seen is that when you have that Zoom one, because of COVID, a lot of the attorneys are just going on Zoom. They're in a whole nother state, but they're on Zoom if they decide to even go through with it. A lot of them maybe won't, depending on your case, but they will mostly be by the documents 100%. And they could just drop out, hear the case and then say, okay, we're going to move to dismiss, or let the judge just go through with it and make a decision, because they're not there not really spending too much time or money, and they really don't know that judge. They're just like, here's our information, that you rule on their information that was presented against what we presented. If the plaintiff attorney is there, like one of the attorneys that is in the area, maybe always seeing the judge, you have to get them into the situation of where they would want to back out of it. And by doing that, it's basically done the same way, but you're really challenging them very hard on them representing their client. Because remember, they're representing a client that is not in their state. They probably make good money from just taking on and showing up to court for them, but they, if challenged the right way, which it's rarely done, is that you have to make it in a way for them to be able to save face to quit. I've seen this a lot. There are some of these debt collection attorneys. I have a few here. You probably heard of Doberstein Law and Cohen Law Firm. These are very aggressive law firms, debt collection law firms. And for them to drop out, you have to actually get to where they are, you got to put them into a position of where they have to say that they've reviewed all of the documents, not just taking the word of the third-party debt collector that they're representing. It has to be where you put them and say, you, attorney that's representing one of these two companies or another company, did you review those documents, and do you know that those documents are 100% accurate? And this is where you end up having these types of cases get dismissed before there's even a court date. Or they might have a court date and have you come in there. If you show up, they'll end up just saying dismissed without even having the judge do anything on it. That's the way that it's usually done if that attorney is there on site. So the things to keep in mind when challenging LVMV funding, when challenging portfolio, when challenging any debt collection law firm that is dealing with collecting debt that they purchased, is that you have to challenge the claimed amount. Like, I know I say it over and over again, but this is your solution. This is like the solution to your puzzle to be able to get you moving in the right direction to be able to get your case dismissed. And we're talking about dismissed with prejudice, where they'll never be able to bring this back, because this is something that they just cannot overcome. So some of the other things that you need to watch out for when they're submitting documents to you, you're going to have a summons, and you need to respond to every point in that summons. It's considered an allegation. Some people don't like me using that word because usually with allegations, a lot of people think of it as, criminal. But in a court summons, this is what they're alleging you did. They can't state 100% fact that you did it. They're going to allege that you did it. And so you need to respond to each one of those. At even the simplest one that say that you live at an address or you live in a county, you need to respond to each one of them. You don't never want to put yourself in a situation where you're disregarding the court. No, they don't expect you to be an attorney and understand and know all of this stuff, but they do want you to respect answering. And they would say to you, if you don't know how to do this, then why don't you get representation? But we all know how are you going to get representation when you can't even pay the bill that they're trying to come after you for? You would probably just say, well, I'd rather do a settlement on the bill. So it's like this push and pull situation. It's like, do I do this or do I do that? Because of the situation that you could feel that you're in. And that's why it also gets very emotional. So you need to respond to it. I see so many people who send us paperwork to the office, and they send the part about the bill from the original creditor, the statements. And we're like, that's part of what they're giving as their evidence. But what you need is to be able to respond to that court summons. So pay attention. It'll have either complaint or court summons, and it'll have this 1, 2, 3, 4, 5, these points, and those will be allegations. You gotta respond to those. Next thing is that you need to see if they have a proof of service document that's inside of that with the packet that they give you, because they need to prove service, and you need to also see what is required for service in your area. The other day, a person said that a 14-year-old or 14-year-old niece got the summons, and in their area, you cannot give that to anyone that is not over the age of 18 or above, an adult, considered an adult. You can't give it to a child. So that would be a way to have the whole thing thrown out. They might try to come back later and serve at a different time to make sure that they get the service to an adult. But this is some of the tactics that they'll use, and you have to know your rights on that. Another thing that you have to look at is you want to look at the documents that they actually present to you, showing that they actually own that debt and how they got that debt and who is signing off from it from the original creditor. You want to make sure that all of that is correct. One of the things that we found with it was Credit One Bank. We found this with Credit One Bank, is that Credit One Bank specifically states that a debt collector cannot buy the debt, or portfolio company cannot buy the debt and resell it or assign it to another debt collector. This is actually written into their contract of sale when they sell off their portfolios. So you should look and read that. A lot of people skip over that page, but if you read it, you may find that your debt was not actually purchased by the third-party debt collector who is suing you, and there is no documentation showing the purchase that third-party debt collector even had purchased the debt, that it was maybe assigned and they made this affidavit document in between. You just never know. You want to read through those. You just want to take your time and look at it and take notes, because this will be the way that you'll build your affirmative defense. The other thing is you want to look at the exhibits that they attach. They're going to have bank statements. They're going to have, some other documents, including the one that I just talked about. But you want to look at all of them, because this is going to be where you can find holes in, number one, did they provide the complete account number? Did they show how that claimed amount, that dollar amount, added up to be that way? Or did they just submit one document? On that document, was the debt shown when it was charged off? And when it was charged off, was it past the statute of limitations or not past the statute of limitations? We just finished a court summons response for a client where the debt was past the legal statute of limitations to be able to sue and to be able to collect. So that's like a double one. Past the statute of limitations to be able to collect, and also when it's past the statute of limitations, a debt collector cannot sue for that debt. A lot of people don't know that. They cannot sue for that debt. The next thing that you need to watch out for, this is one of those tricky documents that they'll throw in there, is that they will have a document that'll say, and I got my notes here, it'll say an affidavit from an employee, and it'll say like that this individual is over 18 years of age and that they have reviewed and they know the way that this company keeps its documents. This is the gimmick behind that letter, is that they're trying to make it look like they know how the original creditor handled their accounting. There's no way that they would know that. But what they're actually saying is they know how the debt collector handles their accounting. But if you look at the letter, you can see how the court can get confused, because it really states that it's more focused on the accounting of the records, but they don't say specifically who, or even if they do say specifically who, they're trying to say like it's a transfer of the documents from this place to this place and that they have to be right. Obviously, that is not enough to stand if you challenge it. If you don't challenge it, it's going to be enough. The next thing is you want to see to make sure that there was no issues that you had with the original creditor. One client that comes to mind was she had an issue with a credit card company. They were in the dispute process. She actually had letters from the credit card company saying, we know that these charges were not yours. And they still ended up charging it off and selling it, and didn't even resolve the matter at all, just didn't resolve it. And we had to go back and forth with them, and they stated in the end that it was just something that accidentally got put into the portfolio. That could happen with your debt. You never know. Also, you need to know if your debt has been canceled. I kind of figured this out by looking at the credit reports when the original creditors were using certain words such as canceled by original creditor, or canceled by account the account holder, or canceled by the credit card company. Like, it would have that in the comments, and I was like, why would they put it that way? It says charged off in one section, and then why will it say canceled? The reason why it could say canceled is because it could be canceled with a 1099-C. That's a step different than just a charge off. And so what we had our clients do is to call the IRS, and sometimes it could be a pain because you're going to be on hold for a long time. But if being on hold for 2 to 3 hours made the difference between you not having to pay a debt that was canceled for $5,000 to $10,000, I think that would be well worth it. So you would have to call the IRS to find out if a 1099-C was filed by that company. But also, what I tell people to do is a 1099-C filed by anyone in your name. Now, don't get mistaken with a 1099-C, any C, like for income, like you worked as a contractor. No, you're talking about canceled debt. Did anyone send a 1099-C cancellation of debt in your name to the IRS? Currently, we know that it's been taken upwards of 1 to 2 years from the filing of the original creditor to even hit the IRS and to get that notification sent back to people. So this is something that you need to really be aware of. And then I don't know if I had said it, but you want to make sure that that bill of sale is 100% accurate and showing your information on that bill of sale. Don't let them just get away by saying that it was just thrown into this big pool of debt. No, that's not good enough. You want to get something that says that your specific account, your name, everything was in that portfolio. Make them go back and get it from the original creditor if they have to do that. Most of the time they won't be able to do that. But this is part of you building your affirmative defense against them, because you have a right to do it and you might as well fight. So to get back to the inspiration for this video is that we have our 3 people. We had the people that just choose not to fight. We had the people who want to do something about it and they, move forward. And then we had that middle group of people who, for some reason, believe that they can only make a move if they know 100% that they're going to win. Again, this is in the hands of a judge. The judge has to make the decision. There is no way anyone can guarantee you an outcome. What you can guarantee is that you put yourself in the best position. And you can go to our website. The link is below this video, where you can see where people have sent in their dismissals from cases upwards of 28,000, 5,000, 2,000, 3, 4, all across the board. It didn't matter the amount. The feeling of success was the same for all of them. It didn't matter what amount. They just felt a big burden that came off of their shoulders by being able to win their cases and stop debt collectors who buy their debt in their tracks. So if you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, What Makes Us Different, so you can see my 8-point validation process and my 2-phase settlement process. If you need your credit reports and scores, go to the website, the3scores.com to grab your TransUnion Equifax Experian credit reports and all 3 scores. If you have debt collectors coming after you, grab my 3-pack of letters. This is early in the game. You want to grab this set of letters. statute of limitations letter, debt validation, and cease and desist collection activities letter. The instructions are on top of those letters. You do not need, if your debt is past legal statute of limitations, there's no need to do a debt validation or anything. You just got to notify them. And if you have a debt collector trying to sue you in court, there's a link below this video. It's called defense. You will debt collector defense, and you can see what that's all about to get help with any court summons that you have from an original creditor or debt collector. It's just if you're dealing with an original creditor, we would tell you, what the process that would work with dealing with original creditors. That's a little bit different than dealing with someone who buys your debt. Thank you for your time. This is Stephen A. Williams, president and founder of thecreditrepairshop.com. Make sure you subscribe to the channel, post your questions and comments, and like this video, and hit the notification bell.